Hello, everyone. I'm Maggie LaBranch-Gonzales, and I'm an attorney with Litherland Kennedy and Associates. We're an estate planning and elder care law firm located in Campbell, California. First of all, happy Pride Month, everyone, especially to our LGBTQ plus community, our clients, and our friends. Today, I thought I'd take the opportunity to answer some of our LGBTQ plus estate planning frequently asked questions. So number one, all right, let's start out with the most common question that I get is, if I am incapacitated, will my spouse or partner be able to manage my finances for me? I'm incapacitated. Will they be able to do it? And the answer is no. Your spouse or partner has zero legal authority to manage your finances if you are unable to do so. I know, it's sort of shocking, right? Your spouse or partner would have to petition the court in what we call a conservatorship. You've probably heard of that, in order to be appointed as the person to be able to manage your finances if you are incapacitated and unable to do so. You do not want to get stuck in a conservatorship. It's time consuming and it is very expensive. And what you may not know is if you are not married and you are not a registered domestic partner, you are not in the hierarchy of being appointed by the court. You can make an argument for it, sure. Will the court pick you? I don't know. The court has an entire hierarchy established by the state law that says who gets appointed in the event you are incapacitated to manage your finances. So if you're married, it's your spouse. If it's you have a registered domestic partner, they get preferential treatment. After that, your parents, your kids, your sister, your sibling, they're the ones that are on the list. A partner of 20 years, they're not listed on the court's hierarchy. So you are risking that your partner of 20 years is not going to be able to manage your finances. And so how do you avoid that? You need to have a power of attorney nominating the person that you choose, that you select to be able to manage your finances. Can you imagine if you had a partner of 20 years and you didn't have a power of attorney nominating them, and suddenly your family shows up and says, no, I think that I'm the better person to be making these financial decisions. The court gets to decide, is it the partner or is it this family member who maybe you haven't been associated with for the last 20 years? The court gets to decide. And now you're thinking, oh, well, if that's about my finances, what about my medical decisions? Clearly, my spouse or partner would be able to make my medical decisions. And again, the answer is no. They do not have the legal authority to make your medical decisions if you are incapacitated and unable to do so. Again, shocking, right? Here we are going back to court to see the judge to ask to be appointed as the person best suited to make your medical decisions. And you already know the situations of what this looks like. So to avoid that, again, you want to have the healthcare power of attorney, which is going to nominate the person that you have selected that is best suited for you to make your medical decisions if you are unable to do so. Another frequently asked question I get is, well, will I be able to make decisions about my spouse or partner's remains if they've died? In California, the law supports the spouse or registered domestic partner to be able to manage the remains for the other spouse or registered domestic partner. Again, if you are not a registered domestic partner, you have no legal authority to be able to manage or make decisions about what happens with the remains of your loved one. Okay, well, how do you prevent that? Again, you want to have that healthcare power of attorney that nominates the person who's going to be able to control what happens to your remains after you pass away. Now you guys you're all thinking, right? Your wheels are turning. Another frequently asked question: does a domestic partnership provide all of the benefits that a marriage, a marriage does? Yes, no, maybe, it depends. Mostly no. A registered domestic partnership, right? I keep saying registered because the distinction is important. You can't just say we're domestic partners. It has to be an official registration. It is recognized in California, and California does grant many legal benefits that are similar to a married couple. However, the federal government does not recognize a registered domestic partnership, and it treats it much differently, especially tax-wise, than it does a married couple. Many states also do not recognize a registered domestic partnership. Even if you were registered here, they may not recognize it there. So it is a big distinction if that is something you're concerned about, how that would affect your rights between each other or taxes or anything like that. Let's switch gears a little bit. What if you have children? Would your spouse or partner be appointed as the guardian of your minor child if something happened to you? And again, it depends. If your spouse or partner, is their biological child or it was adopted by your spouse or partner, then yes, they would be appointed as the guardian. Otherwise, if you have no document like a will that appoints the person that you would choose as the guardian for the court to take into consideration, it's not guaranteed that your spouse or partner would be appointed as the guardian for your minor child. The court would take into account anything that you've nominated in your will. If you don't have a will, then the court would just appoint who they think is in the best interest of the minor child. Another frequently asked question: what if I've transitioned or I've changed my name, or maybe someone I've nominated as an agent in my documents or a beneficiary has transitioned or changed their name? Would I need to update documents that I've already created? And the answer is it's not necessary if you have, or if your agent or beneficiary has legally modified their name and or gender to align with their gender identity. However, it may make it easier or more comfortable in the long run for you to update your documents. And I'll give you an example. Let's say you've passed away and you've nominated a friend as your agent, and over time they transition, they've changed their name, they've changed their gender identity to match what they have chosen as their gender identity. If they have to go to a bank and the documents that you have appointed them is different than what their legal identity is on their ID, for their government issued ID, they would have to show documentation, like, for example, a court order showing that they've changed their name, or other documentation showing that they used to be referred to as this, but now they're this. If you think that would make them uncomfortable, or it would be a headache for them to be able to do that, then yeah, it may be something to consider to updating. But again, is it necessary? No, but it may make it easier, simple, more comfortable for them in the future. Let's see. Is there a tax if I give assets to my spouse or partner? So this is a fun tax question. It really depends. See, federal law allows married couples to give each other an unlimited amount of assets, gifts, right? So you can give them $1 million, they can give it right back. It doesn't matter back and forth. However, federal law does not recognize non-marriage relationships. We just talked about this. So again, your registered domestic partnership, just the partner that you've had for 20 years, you're not registered. It is limited in how much you can give back and forth because you're not married. Again, you're not married. However, with that being said, right now, the federal tax exclusion is approximately $11.7 million. So if you gifted somebody some money and you're not above the $11.7 million, which most people are not, and you're not married, then you're probably well within the gifting limits. You can also gift $15,000 per person per year. And so that might be something to consider if you wanted to gift some money back and forth, or to other people, or to me. Hi. Just kidding. Don't give me money. Okay. So the last question that I usually get is, well, is it a good idea to have an estate plan for an LGBTQ plus person or a married couple? And I think I've given you plenty of reasons why an estate plan is really important. We talked about incapacity planning. We talked about remains. We've talked about transitioning or taxes. There's a lot of other reasons that you may consider it. If you're married, for example, you can give your spouse, if you died first, creditor protection, sheltering some of the creditor, not sheltering, but giving them some creditor protection, asset protection, minimizing some tax concerns if you do have a taxable estate. If you are not married, then planning for incapacity, or even planning for probate. In both cases, whether you're married or unmarried, you want to avoid probate because, again, now that's public. There's fees and costs and time-consuming things you have to think about with a probate. You may not want everybody all up in your business, and that's another reason why you don't want to go through a probate. So having the comprehensive estate plan, having the trust, having the will, the 2 powers of attorney that we talked about are very important. Whether or not you are in the community or just married or single, you're married or single, or you have a registered domestic partner, all of these things are important. Every person over the age of 18 should definitely have some sort of an estate plan, especially some of those powers of attorney that we talked about earlier. Now, if you're interested in attending some of our seminars, our webinars, we have them all now online, then there'll be some information. Check out our website and please like us, and thank you for watching.